But the intention since the very beginning was to produce locally. And Article 2 says that the remuneration due to the holder of the patents mentioned in this preceding article, Article 1, is hereby established in 1 5/10, or 1.5% of the cost of the medicine produced and finished by the Ministry of Health, or of the price of the product delivered to the latter. So that covers two possibilities. In the first 1.5 years, the product was imported from international suppliers, and after that it was produced by one laboratory which is linked to the Ministry of Health. Article 3, the holder of the patent's license is obliged to make available to the Ministry of Health information necessary and sufficient to the effective reproduction of the protected objects. This is about disclosure of the contents of the patent. And we also thought that it would be extremely important for us to have all the elements of the patent fully disclosed so that we could start producing this medicine locally. And oddly enough, only 1.5 years after the compulsory license was issued, could we start production in Brazil. And there are two elements or two main reasons for that. One is that the patent was not, at least the patent as contained in our National Patent Office, was not sufficiently detailed to allow for the immediate production of it. And on the other hand also, we probably overestimated or underestimated, in fact, the complexities of the manufacturing issues involved in production of this medicine. I'm referring to this issue because it's really important, and it shows how complex it is to start producing a medicine such as this in a country. And Brazil is a developing country, but it does have some capacity, technological and manufacturing capacity. I'm not even referring to the system of the paragraph 6, which is for countries that do not have manufacturing capacity. For a country that has the manufacturing capacity and it has some expertise, it took 1.5 years for us to start producing this medicine. And so the other provisions of this decree are not very relevant, and probably I will stop it here. But the lessons learned in this process for us was that the declaration, of course, the flexibilities contained in the TRIPS agreement are essential for access to medicines. But it's not easy. It's very complex to use the system as it is. And that's why I think that we have to explore all the possibilities that are there. Rather than trying, let us say, to embark on new initiatives. And here one final comment also, which I would like to share with Jamie. One of the problems is that the production or the access to medicines has two elements, if you wish. One is access to existing medicines, and one is access to future medicines, to innovation. And one of the problems that today, the countries that, the companies that manufacture both are sometimes linked, or the prices of the two are linked in the same equation. And the production of existing medicines are usually made by companies that are, let us say, reaping the harvest to invest in new medicines which are in the pipeline. And this is, we have to really to develop new business models to tackle the idea of new medicines and innovation in the sector. And just one final comment here, which I bring to your attention. The Doha Declaration was really developed to deal with this, primarily with the issues of access to medicines. But the interplay between public health on the one hand and intellectual property on the other is much more complex than that. And I would like only to mention one issue, which is now in the TRIPS Council, which it's interesting. It is the questioning by some countries of the Australian legislation on plain packaging for tobacco products and cigarette products. And of course, this new legislation is being challenged not only on intellectual property grounds, in fact, on labeling requirements that would dilute the power of the brands, but is also being challenged on the grounds of the technical barriers to trade agreement. But this is a completely new issue, which brings to life again the importance of the declaration of Doha on TRIPS and public health. But I would stop here. Thank you.
Thank you very much for this very concrete case example of how TRIPS declaration helped to get a compulsory license going in Brazil in order to save costs for the Ministry of Health. Michelle, you are now invited to give your presentation.
Thanks, Martin, and thank you to the organisers for inviting MSF to speak here. It's inevitable when you come towards one of the end speakers that you will repeat some of the things that have been said before. But I'm here really to talk as MSF. We are a medical humanitarian organisation, and as such, we treat people living with HIV and other diseases, but we also seek to source and purchase medicines. I think when we're talking about the background to the Doha Declaration, what was really burnt into our consciousness at that time was how patents and access to medicines would really affect medical outcomes. Let me just see how this works. So what I want to just go over quickly is to share some of our experiences, if I can actually work this mouse. I think it's important to think about the situation prior to TRIPS. In the early 1990s, approximately 50 developing countries either excluded medicines from patenting or provided shorter periods of protection. And in Brazil, for example, they didn't have pharmaceutical patents. And importantly, in India, they didn't have pharmaceutical product patents. And what did we learn from that? And what did we gain from that? Well, I think this is perhaps a famous graph from MSF, and a lot of attention is paid towards the end of that graph, which is basically showing that the results of generic competition have lowered the price of medicines from, this is the first line treatment for people living with HIV, which was offered to us at just over $10,000 per patient per year. And we were just amazed when at that stage, Brazil, because they were able to make generic drugs, were prepared to make a donation to us, which was just below 3,000, which enabled us to set up initially our treatment centre in South Africa. But again, what really brought this home to us was the deal that Jamie helped broker with Cipla, which offered us that same cocktail of drugs for $1 a day. And that was possible because these industries were able to be built up because they did not have patent protection. And what we have seen is a confirmation of our own experience. Because the cost of the drugs went down, and not only the cost of the drugs, but it was the generic producers who made the drugs easier to take for people living with HIV. They produced the first fixed dose combination, which was combining many pills into one, which you could take early in the morning and at night, to deal with the accusation that we often face that you couldn't treat people living in Africa with a complex treatment like HIV because they couldn't tell the time. We disproved that, as did the people living with HIV. But what we've seen here, and repeatedly seen for donors, is that the cost of medicines, because they were lowered, massively helped the scale up of treatment of people living with HIV. And we're now in a situation where over 6.5 million people living with HIV have treatment. We still need more, but it means that if we're going to try and reach the targets that we saw in the UN high-level meeting on HIV, where they made a commitment to putting 15 million people on treatment by the year 2015, we have to repeat the successes of the past, and that includes ensuring that the costs of medicines stay low. I think the other point to note is how important at the moment the Indian generics industry has been to the treatment of HIV. If you see in 2008, 87% of the ARVs that are going across the developing world are produced by Indian manufacturers. And if you're talking about pediatrics, it's higher than that. For MSF, we source 80% of our ARVs from Indian generic manufacturers. The other point that I think is really important prior to Doha is that it was really through confrontation and litigation that this issue of access to medicines came to the fore. It is led by people living with HIV who were fighting for their lives, and they recognized that it was not a medical issue that prevented them from getting treatment, but it was the price of the medicines. So this background then led to the Doha Declaration, and as we have heard, the Doha Declaration, I think, was important for a number of reasons. Not just that it clarified the right to use the flexibilities that we've heard about, like compulsory licensing and parallel importation, but it also gave, at that stage, we hoped, the political space for the use of those flexibilities. It also gave political recognition on its face for the first time really, that intellectual property and trade rules could have a negative effect on access to medicines. And this tension that is played out in paragraph 3, which says that while they recognise that intellectual property protection is important for the development of medicines in some countries, they also recognise the concerns about access to medicines. And really what this declaration was saying in all of its parts was that IP protection must take into account the public health needs of society as a whole, rather than only as a mechanism to protect the limited commercial interests of the few. And it's led to a cascade or continued debate about the role and extent of intellectual property in incentivising innovation and access that we've heard playing out here this morning in discussions about the development agenda and are continually discussed at the World Health Organization. Why are we still discussing them? Well, for HIV, we are now seeing the reality of the TRIPS agreement and patenting biting in key generic producing countries. HIV is a lifelong disease and people will inevitably develop resistance to their treatments. And what we're seeing is that the first-line treatments that were available because they were off patent and generic production was possible will not be the same for the second-line or third-line treatments. We are already seeing second and third-line treatments for HIV under patent in India and other key generic producing countries. And if you look at the cost comparisons of that, we are looking for moving for second-line treatments up to 7 times more expensive, and possible third-line treatments, if prices are available, are over 19 times more expensive. And these prices, as I say, are not necessarily available in all countries. And this is a reality. We are already seeing in Kailisha, which is one of our longest running treatment centres, which we run with the Ministry of Health in South Africa, people living with HIV are now developing resistance. So for the first-line treatment, we're seeing about 14% of people developing resistance after 5 years. For second line, there are about further 25%. Now, you can use adherence treatments to ensure that they can go back and stay on second line, but even with that, we are already seeing some of those needing third line treatments. So this is an indication, I think, of some of the longest running projects with the longest running cohorts of people living with HIV. This is an indication of what the world will be facing. And I think that this is recognised not just by treatment providers as ourselves, but also by donors. There was a truly inspiring speech by Hillary Clinton when she talked about the desire or the aim for an AIDS-free generation based on the new science that we have seen that treatment can be prevention. But she also acknowledged that one of the key issues in PEPFAR, which has done so much for treatment of people living with HIV in Africa, was to ensure that they could repeat the successes of before, that they could lower and contain costs. That requires a variety of things, obviously bulk purchasing and the ways that you ship, but crucial to PEPFAR's success was access to generic medicines. And continuing to drive down those costs is a challenge for donors and for developing countries. What we're also seeing is that there is an increased segmentation of countries, even though they may all be facing having to treat people living with HIV, either through public provision or through private pocket. We're seeing that where there are patent barriers or generic prices are not available, for so-called middle-income countries, we're seeing that the price of tenofovir is over 6 times more expensive. But we're also seeing for the first time, and we've noted this in Untangling the Web, which is our price guide publication, that companies are increasingly excluding lower middle income and middle income countries from differential prices. So we've seen them cease to offer standard price discounts. What that tends to mean is that the negotiations are on a case-by-case basis. They are untransparent. It tends to lead to price increases. Abbott is excluding a key drug from its differential pricing in low and middle income countries. And it's no surprise that civil society groups have currently taken action against Abbott to seek the lowering of the price of the price of leponavir and ritonavir. And Tibertech and Johnson & Johnson do not provide differential prices at all for some of their key third-line drugs. So, I mean, I'll go through this very quickly because others have talked about this. So, Doha held the promise that countries could use the various flexibilities to ensure access to medicines, and the use of them has been mixed. There have been exclusions from patentability, and we've seen that used to issue or to enable access to generic drugs, but not all countries are using this. One of the key things that has been quite important for us is refining the patentability criteria. There have been 15 patent grant oppositions to HIV medicines issued by civil society and others in India, and that has led to a key HIV drug, tenofovir, being successfully opposed, and also nevirapine syrup, which is necessary for a child formulation, was also successfully opposed. But the provision that they used to oppose that, the so-called 3D, has come under relentless attack from Novartis, who is currently at its 3rd attempt. Firstly, they tried to declare that 3D was not constitutional. They failed. They are now seeking to gut the contents of 3D by seeking to widen its application to trivial and well-known changes to medicines. And that court case will be heard, we think, next week. But it's just an indication that although Doha said that that patentability standards were open for countries, it is not a protection against companies and others using litigation in court within national jurisdictions to try and limit those flexibilities. We've also seen the benefit of parallel importation. MSF has in the past used the ability to source the market for low-cost drugs to parallel import HIV medicines into Kenya. But again, we have a concern that this type of flexibility is threatened by the overbroad definition in new ways to enforce IP provisions, which are anti-counterfeiting provisions. We've also seen and benefited from the use of compulsory licenses. There's a bit of a myth that compulsory licensing hasn't been used outside the well-known cases of Thailand and Brazil, but as my illustrious predecessor showed in her book, Ellen Turin, there have been over 52 developing and least developed post-Doha compulsory licenses. either through government use or implementation of non-enforcement of patents. Mostly these have been for ARVs, but also for cancer and heart disease. However, the reality is that generic producing countries have faced retaliation for their use. While we have seen the benefits and have used the benefits of Doha, it is important to point out that it is not a static environment. The use of the flexibilities has not only been uneven, but it has been under relentless attack from the pharmaceutical companies and governments through bilateral agreements. And we're presently seeing that in the EU-India Free Trade Agreement and the Transatlantic Pacific Partnership, which I know Sonia will talk about in more detail. What have been the other responses to this concern about access to medicines? Well, as I said, companies have offered differential prices, but our experience in HIV and other areas is that these discounts are not steep enough, and they are not as effective as generic competition. More importantly, they are also not a solution to patent barriers to the development of fixed-dose combinations and future pediatric formulations, which we desperately need, not just in HIV, but in TB and other areas. And to give an example outside of HIV, when companies have claimed in the past that they're selling at cost, and this is what they're giving a discount for, we've seen further significant price reductions once competition has set in. GSK recently announced that they were going to cut or discount all of their drugs by 75% for least developed countries. But 10 years ago, GSK cut the price of one of their drugs, Combivor, to $2 a day for African countries. That was 88% lower than the price discount they're offering now. And rival manufacturers now sell that medicine for 25 cents per day. So even at cost discounts, competition has shown that it can lower it. The other thing that is now being looked at is public health-driven voluntary licenses. The reason I say this is because voluntary licenses are not new. They have always been around, particularly in relation to HIV, but they've often been prompted by the threat of litigation, as happened in South Africa, or the fear of successful patent oppositions, which happened with the original Gilead license. I think what's different now is that the medicines patent pool, which is backed by Unitaid, is seeking to act as a pro-public health broker in this voluntary licensing debate. And they've shown that they can achieve improved licensing terms, particularly for the NIH. For the Gilead license, there were improvements in geographical scope, but there are limitations. I think the patent pool hit the wall that we have seen in untangling of the reluctance voluntarily to serve the needs of lower middle income and middle income countries. It's limited to only Indian generics, and there are API restrictions. But what I think is important and should also be learnt by WIPO is that the medicines patent pool has benefited from WIPO's work to create a patent database so that you can check the patents. It's benefited from the WHO's work in identifying the key medicines. And it has also, I think, set norms for transparency. And we would hope that the WIPO, when it is looking at its own consortium, which it recently announced, which is beyond a patent pool but is for neglected diseases, will recognise that if you're claiming that something is for public health, you need to ensure that all endemic countries are covered. And we are concerned that the current WIPO consortium, which covers neglected tropical diseases, only covers in the Americas only one of the endemic countries. So we've talked about the responses to the Doha Declaration, but I want to highlight quickly that there is a particular issue that we have a concern about in relation to importing countries. As I've said before, most of the first-line ARVs pre-TRIPS were not patented in producing countries. That meant that you could get away with, if you were in an importing country, a single compulsory license or government use. But that situation is going to change. In 2016, the least developed countries, unless they do something about it, will not be able to rely on non-enforcement. This will block regional production and supply ambitions in Africa unless a workable solution is created. We also tried to use the August 30th decision, and we found that the test set in Doha to find an expeditious solution has been failed by the August 30th. After 4 years, we had to withdraw from its use because it took too long, and what we have seen is only one compulsory license for a single order for a time-limited period for a single country. It is unrealistic, if we are going to scale up, to rely on a drug-by-drug, country-by-country, case-by-case decision-making process. It ignores the realities of generic production, it ignores the realities of stockpiling, of treatment needs. And we're astonished that it is still not accepted within the TRIPS Council to even hear from people like MSF who've tried to use this regime, or the generic producer who used this regime in Canada and who said they will never use it again, to hear from us, because it's important as we go forward that there has to be a solution if countries are going to rely on this. And we would ask that the TRIPS Council hears from us, but also more importantly, finds an expeditious solution. So finally, I think that the Doha flexibilities provided limited space for continuing to ensure access. But we are continually fighting a shrinking policy space, and it doesn't replicate the easy use of the pre-TRIPS system. We're seeing increased barriers to generic production, and that creates perverse incentives for generics to stop providing new medicines to developing countries and to focus on off-patent medicines in developed countries. And we're already seeing some indications of that from Indian generic producers. Importantly, it doesn't address the needs for research and development for neglected populations or a sustainable system for innovation and access. And there's a continued need to focus on the core questions of how access can be ensured, how can needs-driven R&D be financed, and how should the burden be shared. We are now kind of, in a way, back to where we were in 2001, but with more hope. The science is in that we can treat more people. We have the potential to use the flexibilities, but we are also against the background of a funding crisis and increased commercial concern about seeing developing countries as markets. We've seen the rise in TRIPS plus demands by developed countries, and I'd agree with Carlos that sadly we are seeing the Doha Declaration used as a diversionary tactic by the US and the EU. They say when we complain to them about the conditions in the free trade agreements, it's okay, we've referred to the Doha Declaration. Therefore, you don't need to look at the other provisions, but those other provisions are harmful. Although we've seen gains in HIV, will we still see those gains elsewhere? Because the Doha Declaration was cut from even being mentioned in the UN high-level meeting on non-communicable diseases. So what then do we think are the conclusions going forward? Well, we're in a changed environment. New products are patented in developing countries. Prices won't come down automatically. Deliberate action will be needed to counter the consequences of global pharmaceutical patenting. In the short term, we feel that countries need to solidify the gains by implementation and use of the flexibilities. In particular, we think LDCs should extend the 2016 deadline, and there should be an immediate review of the August 30th decision. It's important that trade policies are aligned with the promise in the Doha Declaration to remove TRIPS and IP provisions and to try additional approaches such as the medicines patent pool. But in the medium term, we think that the TRIPS agreement has consistently been renegotiated upwards, and we think it's time to explore the question about whether the TRIPS agreement should be renegotiated to look at the ways to ensure that it could become a better use for access to medicines. And this is one of the questions that we're discussing in our meeting next week. And finally, to ensure innovation and access, we support the exploration of the global framework for R&D, or the R&D Treaty. Thank you.
you, Michelle, for this very comprehensive. Maybe we just request you to write this up in a good paper. And now we invite Sanya Smith from Federal Network. You're going to show it.
Thank you. I'll be quick because, as Michelle said, a number of the presenters have already covered the same ground. So, as you know, of course, the Doha Declaration said that it reaffirms the use of the TRIPS flexibility. So what I'm going to be looking at here is whether actually this has been honoured. And of course, we're looking at TRIPS and public health, so I won't look at TRIPS flexibilities in other areas like copyright. And just looking at the main provisions, as we don't have much time. So far, of course, what we've seen is that the spirit of this Doha Declaration has been undermined in some North-South free trade agreements, and I'll also look at WTO accessions. So you can see first here that we have the WIPO conventions, where the TRIPS flexibility is you don't have to comply with any conventions beyond those required by TRIPS. But of course we see in the WTO accessions, including by least developed countries like Vanuatu, that they have to join additional WIPO conventions. In the case of Vanuatu, it's all or unspecified WIPO conventions. This was in the version of Vanuatu's Working Party report released in May this year by the government. And of course we see it in free trade agreements, such as those with the European Free Trade Association, European Union, and US free trade agreements. What about patentability standards, which are important as we heard earlier? Again, the TRIPS flexibility, of course, is that you can define patentability within the Article 27 criteria, and we heard about India's Section 3D, which says that it is not an invention if it is a mere discovery of a new form, which does not result in the enhancement of the known efficacy. What do we see in the US proposal in the Trans-Pacific Partnership Agreement currently being negotiated with 8 other countries? And this, of course, is the leaked text. You can see at the bottom that you must allow patents for new forms, even if they don't result in the enhancement of the known efficacy, i.e. it's deliberately prohibiting you from using India's style of patentability standards. And you'll see in the extracts of the UN Special Rapporteur on the Right to Health's report that I put outside, this is of course against his recommendations about high patentability standards. Patents on new uses. Again, of course, the TRIPS flexibility is that you don't have to allow patents on new or second uses, but we see that in some developed country free trade agreements, such as EFTAs with Korea, US free trade agreements, the current US proposal, that you must allow patents on new uses. And of course, the UN Special Rapporteur on the Right to Health, in the extract that I put outside, said that you should establish high patentability standards in developing countries and least developed countries, and exclude new uses and combinations. I haven't looked here at patents on plants and animals, as they have a less direct effect on medicines, but of course some US free trade agreements also require this, even though the TRIPS flexibility is not to give patents on plants and animals. Patents on diagnostic, surgical and therapeutic methods. Of course, TRIPS says you can exclude these from patentability, and therapeutic methods are another way of getting a new use patent. But we see in some developed country free trade agreements, including the US current proposal in the Trans-Pacific Partnership Agreement, that you must allow patents to be available for these diagnostic, therapeutic and surgical methods, again against the recommendation of the UN Special Rapporteur on the Right to Health. What about pre-grant patent opposition? Of course, the TRIPS flexibility is that pre- and post-grant patent opposition is allowed, yet we see in some developed country free trade agreements, like the US free trade agreements listed, that you cannot have pre-grant patent opposition. Again, this is against the UN Special Rapporteur on the Right to Health's recommendation that developing countries should have liberal pre-grant opposition. What about patent term extensions? Of course, we know in TRIPS the flexibility is that a 20-year patent term is sufficient, but we see in some developed country free trade agreements, like EFTAs with the countries listed, the EU proposals to ASEAN and India, US free trade agreements such as those listed, that they require patents to be extended beyond 20 years. Again, this is against the UN Special Rapporteur on the Right to Health's recommendations that developing countries should not agree to TRIPS Plus provisions in free trade agreements. In compulsory licenses, The TRIPS flexibility, of course, as we've heard, is that the compulsory license grounds are not limited, reaffirmed in the Doha Declaration. Some US free trade agreements restrict the situations in which compulsory licenses can be used, again against the UN Special Rapporteur's explicit recommendation on allowing compulsory licenses for all grounds. Parallel importation, of course, as we heard, is permitted as a TRIPS flexibility reaffirmed by the Doha Declaration, prevented in some free trade agreements, such as the US-Morocco one, again against the UN Special Rapporteur on the right to health's explicit recommendation about adopting parallel importation. Data exclusivity, as you've heard, is not required by TRIPS, and yet, in some WTO accessions, including for least developed countries like Cambodia and Vanuatu, for their transition period, and in the US free trade agreements, EFTA FTAs, EU FTAs listed, data exclusivity is required. I should add that, of course, Vanuatu's accession was adopted by the General Council just 3 weeks ago. So what I'm talking about here is a trend from 2001, when the Doha Declaration was passed, until as recently as 3 weeks ago, agreed by the WTO membership just down the road here in Geneva. Again, this is against the UN Special Rapporteur on the right to health's recommendations about not agreeing to TRIPS Plus provisions. Linkage, as you heard, is not required by TRIPS. Again, in the WTO accessions of least developed countries like Cambodia and Vanuatu, in their transition periods, they are required to do linkage, and in some US FTAs like CAFTA. Again, this is against the UN Special Rapporteur on the right to health's recommendation. In enforcement, I don't have time to go into things like the US requirements for triple damages for patent infringement in the Trans-Pacific Partnership Agreement, or the TRIPS Plus enforcement being sought in other fora like the World Customs Organization. But just one example here, of course, is the border measures provision, which has been debated here in Geneva. And of course, in TRIPS, you only have to check imports and only for counterfeit trademark or pirated copyright products. Yet in some free trade agreements, especially by the EU, you have to check imports, exports, transit, goods in free warehouses for all intellectual property, including patents. Then, of course, we have the transition periods, which have been discussed, and in the TRIPS, least developed countries can have extensions under duly motivated request. Of course, the Doha Declaration allows it until 2016. Yet Vanuatu's WTO accession, adopted 3 weeks ago, requires Vanuatu, a least developed country, to apply TRIPS by 1 December 2012. It does not have the option of the 2016 extension. Again, this is against the UN Special Rapporteur on the right to health's recommendation that LDC should make full use of the transition period. In the last 3 weeks, Samoa has also joined the WTO, and the accession package is not public yet, but the transition period mentioned publicly is only the 2013, not 2016. And of course, Russia has recently joined the WTO, and that package is also not public, and we don't know how much TRIPS Plus provisions are there. So just some quotes, of course, the recent UNAIDS, UNDP, WHO statement that proposed FTAs could limit the ability to use TRIPS flexibilities, and developed country governments should ensure that any FTAs comply with the Doha Declaration. Of course, the WHO's CIPIH Commission also said that bilateral trade negotiations, it's important that the provisions respect the Doha Declaration and should not have TRIPS Plus. The UN Special Rapporteur on the right to health, again, that TRIPS and FTAs have had an adverse effect on the availability of medicines, making it hard to comply with right to health obligations. And the World Health Assembly, of course, said that member states must take into account in their bilateral trade agreements TRIPS flexibilities recognised by the Doha Declaration. So you can see the pattern here, and I haven't had time to cover the way in which some investment treaties and investment chapters can also provide TRIPS Plus protection. And I think that what you see is that these WTO accession requirements, free trade agreements and bilateral investment treaties undermine the spirit of Doha, and it's a shameful report card for developed countries who have insisted on undermining TRIPS flexibilities despite the Doha Declaration. Thank you.
Well, thank you to all our speakers. And now, because we have limited time, I'm going to open the floor for discussions. I hope we can have 3, 4, 5 questions or comments. Please keep them brief because of the time factor. I hope you're able to stay beyond 3 o'clock, but I know many of you have forgotten your lunch even. So anybody would like to put your comments, questions? I see many good organizations on the floor. Yes, please.
Hello, my name is Karen Garcher. I'm from the U.S. Mission, and I'm afraid there were a lot of views portrayed today. A lot were on one side. I just wanted to focus on one point. I'm a former patent examiner, but I also did a lot of patent training. And when we provide training on novelty and inventive step or obviousness, we're very careful to adhere to the TRIPS minimum standards. We don't encourage, as was suggested by the first speaker, that we have some sort of soft or almost non-existent obviousness standard, because when a patent issues, it stops everyone else, or gives the patent owner the right to stop everyone else from making use of that invention. So if the inventive step standard was too low, then it would have an inappropriate ability to prevent others from using similar versions. And for that reason, the U.S. does not promote the use of utility models. As some of you may know, utility models are something like patents, but they're granted with often only a novelty standard. So we are strong proponents of a good obviousness standard. And as far as India's 3D, we do try to explain that that's not TRIPS consistent. One reason is a patent may be appropriately granted because it has fewer side effects. It may not be any more efficacious, but it could be cheaper to manufacture or have less harm to the environment. So we think that if people stick to the simple standards of novelty, inventive step, or obviousness, they will be guided to a right conclusion. If they try to introduce TRIPS minus or TRIPS plus, I don't think it matters how you characterize it. If they try to introduce standards that are not in TRIPS, then they will be preventing inventors who invented an invention that's worthy of a patent from getting it, and that invention perhaps not even getting the further investment that's necessary to have that drug be approved by the Ministry of Health. And we think that would be very unfortunate to public health. Thank you.
Thank you very much. Any other persons? Yes, Ellen, please.
Thank you, Martin, and thank you to KI and South Center for organizing the first celebration, although I must say the speakers didn't sound very celebratory today. While I don't want to contest anything that's been said, I do think that we're missing out one particular element with regard to the Doha Declaration, and that is its overall norm-setting effect. There's so much outside the direct IP environment that has been possible because of the Doha Declaration, which we might not necessarily see here in WIPO, but which has been extremely important. For example, the fact that the WHO pre-qualification could start doing its work with complete disregard to the patent status of the products that it was giving the pre-qualification to, which has helped enormously to expand the market for these products. And more directly related to my own work at the Medicines Patent Pool, the recent license agreement with Gilead, while I agree with Michelle that there are certainly shortcomings, which you will often find in a voluntary negotiated agreement, the fact that the license also explicitly provides for the sub-licensee's ability to produce and supply in case a compulsory license has been issued, would, I believe, not have been possible had we not had this political background of the Doha Declaration that has affected so many different kinds of works and directions that has been taken in the last 10 years. So there's certainly a whole lot more to be done, but I think we should also continue to use the power and the push that has that has been generated through the Doha Declaration so far, while also looking at other issues. I think Jamie is quite right in saying if we really want to have a sustainable solution to access, we will need to look at the cost of the innovation and how we're going to deal with that. And that, of course, remains absolutely at the core, I think, for the next 10 years. So I hope 10 years from now we'll meet and we can celebrate that one.
Thank you very much. I hope we are here 10 years from now.
Yeah, that's another challenge.
Any other contributors? I see that WTO Secretariat is here, Leo Palma is here, ICTSD is here. All of you are active participants of this declaration. Leo, please. Did you wave or did you say you don't want to speak?
I just
Okay. If so, then any comments from the panelists? Yes, please.
I'm Susan Isiko, I'm an independent consultant. I would like to take maybe a different side, something to celebrate, and I agree with the previous speaker, that it may not be something big, but there's something that come out of that is really inscribed in the decision, the 30th August decision, the possibility of regional mechanisms. And I recently worked on a project where for me it was an eye-opener that if the LDCs try to use what has been provided in the Doha Declaration, use the importation mechanism, but also open up to explore the possibility of setting up regional mechanism to open up trade, it is possible. And Uganda is a case in point, where they've been a plant that is developing, has been put up for manufacturing, and they're using what I'm calling, I look at as a kind of technology transfer from India, from countries that are apparent or look handicapped, but they are looking elsewhere and try to use the mechanism, the WTO mechanism, to look elsewhere where there is no capacity, but to bring in their capacity, and they work together with the local people. And of course, there are issues of where to sell the medicine, and that's where organizations like WHO come in, Global Fund come in. They are exploring or tapping in what I call direct manufacturing. So that Global Fund facilitates the buying of the medicine. Of course, you need WHO to issue the pre-qualification. And I think this is all possible thanks to the declaration. And I agree with our previous speaker.
Thank you. We are hearing more voices on how the declaration has helped. Can we invite our panelists, those of them who would like to respond? Carlos?
Well, thank you, Martin. I'll just address this comment on the non-obviousness test. Well, I'm happy to hear that you intend to apply strict patentability requirements when patent examination is done. I'm sorry to say that this is perhaps not really achieved in many cases, both in the United States and in the countries where the United States is providing advice. So I could show you, and I've done this in many seminars, a number of examples of patents granted in the United States. For instance, a system of reservation for the use of the restroom granted to IBM, or many others, where it's very difficult to see what kind of non-obviousness standard has been applied. And what you see in many developing countries, the fact that the kind of training that examiners receive is not really helping them to do a good job and grant patents where there is something, a real technical contribution to the state of the art. So there is a huge proliferation of patents where you cannot really find anything which is inventive. In the pharmaceutical sector, you find a number of patents on polymers, enantiomers, salts, formulations where really inventive